Hi, this is Theo Watson. Just wanted to talk to you a little bit today about SBA affiliation and the basic approaches to avoid some of the costly mistakes that we've seen out there as attorneys. Um, Again, I'm Theodore Watson from Watson and Associates. We're a government contracts law firm specifically dealing with procurement issues from clients across the country. So one of the first thing that we want to cover is what is affiliation. Um, the SBA applies specific regulations when analyzing affiliate relationships between um, prime contractors and teaming partners, joint ventures, subcontractors, etc. Affiliation usually focuses on the business relationships between two or more companies. And again, we're usually talking about the prime, and in most cases, it's usually a teaming partner or subcontractor. When the SBA looks at affiliation, they primarily look at the ability to control one company versus controlling the other, or vice versa. They actually look at documentation, contracts between the parties, teaming agreements, operating agreements, you name it, the SBA takes a look at it to see if there's any obvious problems with the relationships, or sometimes the not so obvious problems. The primary regulation that deals with affiliation is 13 CFR 121.103. There are a variety of different legal theories that the SBA looks for. Common ones include identity of interest, family relationships, married couples, etc. The other one that usually focuses quite a bit or surfaces quite a bit is the economic dependence rule. And basically what that says is that if you have you as a small business prime have 70% or more of your revenue from another company, in this case, it would normally be either a subcontractor or a teaming partner over the previous fiscal year, and the SBA is going to take a look at that carefully to see if they can assert the economics dependence rule to conclude that you're affiliated. There is no bright line rule. Every case is fact specific. So if you are a company that's contemplating getting into a relationship with a subcontractor or a teaming partner, you want to take a look at these rules to make sure that you don't violate any of them. So as small business, you want to, if you're applying for government contracts, you don't want to wait until the last minute when there's a solicitation out to then quickly find teaming partners or joint ventures, etc. You want to take proactive measures to avoid affiliation. As I said earlier, there's two approaches that we want to take a look at when the SBA looks at affiliation. The most common situation is when you have teaming agreements, and then second, joint ventures. Under the teaming agreements, which is fertile ground for affiliation, the SBA obviously looks again at the 13 CFR 121.103, and there are various factors there that they look at to see whether or not there is affiliation. The other one that they look at is pretty common, is the ostensible subcontractor rule. We'll talk about that in a little while. Basically what that says is that if you are the prime and you are bringing in a subcontractor or a teaming partner, first thing you want to look at is to be whether the teaming partner or sub is the incumbent. That usually raises red flags. But the ostensible subcontractor rule says, in essence, that as the prime contractor, you cannot have your sub or teaming partner perform the primary and vital parts of the contract. The other aspect of it, obviously, is that as the prime, you have to show or demonstrate that you are in control of the actual contract itself. Under the new rules now, you have a little bit of leeway where it says no affiliation if your subcontractors or teaming partners are similarly situated. What does that mean? The primary focus that the SBA would look at is if your subcontractor or teaming partner is also a small business, that's usually good, but they look a little bit closer. For example, similarly situated could mean that it was a hub zone set aside, then obviously your subcontractors would have to be also a hub zone, a small business. Or if it's an 8A set aside, they want to be 8A also. Then second of all, they want to look at the NAICS codes that you are subbing out work to, etc. Not a lot of case law on the similarly situated companies yet, but those are the basic things that you want to look for. The next version of or application of the affiliation rule goes towards joint ventures. Now, obviously, there's the difference between the joint venture and the teaming arrangement is under the teaming agreement, you rarely have a prime and subcontractor relationship, where under the joint venture, the companies join together and it's the joint venture that's the actual offerer. So under joint ventures, primarily a joint venture of 2 or more businesses can submit a bid in a joint venture so long as each of the entities meets the small business size standard. So for example, you could have 3 members forming a joint venture so long as each of the members are small under the respective size standard without having to worry about affiliation. However, even though that may be the SBA still looks to make sure that, especially if it's a non-8A set aside, that your joint venture agreement still has to comply with the JV regulations as far as what must be in the joint venture. The SBA looks at your joint venture agreement and it doesn't meet the statutory requirements, then they're going to presume that all companies are affiliated and hence either join revenues or employees to essentially blow the size standard. Affiliation is a rebuttable presumption, which means the law presumes that you're affiliated. However, it's up to you as the small business to demonstrate to the SBA certain facts that could rebut that presumption. Best way to deal with the potential for affiliation is to assess your relationships now. As I said before, you don't want to wait until a solicitation is out and then try to hurry your way into creating the relationship. That creates room for mistakes. The Office of Hearing Appeals has held that the mechanical application of the economic dependence rule, which I just talked about earlier, is erroneous when a startup company has been able to secure 1 or 2 contracts. Again, revisiting the economic dependence rule, there's a general presumption that if you have 70% of your revenues from one company, that you're presumed to be affiliated. However, there's some exception to this, and the Office of Hearing Appeals made that decision in the case of appeal of Argus and Black, which was a case that our specific firm handled, where we actually reversed the SBA's broad brush approach. I believe it was under the case of Faison, where in this specific case, the appellant, which is Argus and Black, basically just ended up, although showing that they applied for different contracts and they didn't get it, it was just coincidental that they ended up with the significant amount of revenues from its one company. The overall goal is to make sure that the SBA does not merge revenues or employees to put you over the designated size standard. Some tips for avoiding affiliation. You want to take a look at some of your documents and contracts with other firms. Operating agreements that give another company the power to block several types of actions are going to be looked at heavily by the SBA. What does that mean? documents or operating agreements that essentially focus on essential aspects to operating a business is what the Office of Hearing and Appeals looks like. You want to take a look at hiring large business incumbents, looking at hiring their workforce or employees en masse, or which means a significant amount of employees. You want to stay away from hiring employees on the management aspect of it and supervisory. You want to make sure that that comes from your specific company. And you want to make sure that you're not relying on, especially for large business, as a subcontractor for managing the contract. If the SBA sees that, they're going to hastily reach the conclusion that you're going to be affiliated, and those type of relationships are going to be hard to reverse on appeal. Make sure that your teaming agreement is clear as to who is in control. Obviously, OHA looks pretty clear at the teaming agreement and would essentially not focus on speculation by the SBA. However, you still want to look at your facts about the relationship, and it's just not the agreement itself that controls everything. How do you overcome or leave the door closed for speculation? You may want to spell out in your actual proposal what percentages of the statement of work you are going to be, as the prime, are going to be providing versus what your subcontractor or teaming partner is going to provide. That usually closes the door to a lot of speculation. So some final points for you as far as affiliation. The new SBA rules have actually carved out a lot of exceptions and relaxed the possibility of affiliation. However, the facts of each case, you want to look at those carefully. You might want to look at creating a checklist when you're building relationships to reduce the likelihood of being affiliated. Most companies want to avoid waiting until an actual size protest is filed to then have to defend yourself. One of the things you want to do is make sure you have someone on your team that understands the rules, so that before you finalize or submit for your proposal, you want to make sure that you have all your T's crossed and I's dotted. Remember that the new joint venture and teaming rules are different and can still lead to affiliation. So although the new rules is essentially reduces the possibility or the adverse decisions for affiliation for small businesses, if you violate some of the basic underlying principles, such as limitation and subcontracting rules, or you're not complying with the joint venture agreement regulations, then obviously the SBA is going to find you're affiliated. If anyone out there has any questions or need help forming their agreements or dealing with size protests and affiliation issues, feel free to give us a call at 1-866-601-5518. Thank you.